Hello, I'm Assistant District Attorney Darren Allemand. Among my duties at the Jefferson Parish District Attorney's Office, I have the honor and privilege of assisting our District Attorney Paul Connick with putting together our package of legislation every year. In Jefferson Parish, we've been blessed with many resources, and because we believe that those blessed with much have an obligation to work that much harder to give back to our communities, we are very active each year in putting forth legislation to improve our criminal justice system. One bill I would like to talk to you about today is House Bill 67, which became Act 346 when our governor signed it into law. This bill makes changes to Louisiana's laws on sex offenses so as to better seek justice for victims and to better protect the people of our state. Sex offenses are rightly regarded as the most heinous of offenses, both for the moral depravity that it takes to commit such a crime and for the harm done to the victim. Louisiana rightly has very tough laws on sex offenses, but certainly we should always be looking for ways to improve. Louisiana law provides for 3 degrees of the crime of rape, with first-degree rape being punishable by mandatory life imprisonment without parole, with second-degree rape being punishable by up to 40 years imprisonment without parole, and with third-degree rape being punishable by up to 25 years imprisonment without parole. First-degree rape in particular involves a rape committed when at least one of certain aggravating factors is present, such as, for example, the rapist having a dangerous weapon, or the rape being committed during a burglary, or the rapist threatening great bodily harm on the victim, or the victim being under 13 years of age, among others. We felt that the current law could use some improvement to further protect child victims. While a rape victim under age 13 automatically constitutes first-degree rape, often cases involving child victims 13 or older did not involve any of the other statutory aggravating factors to make the crime first-degree or even second-degree, and we often found ourselves limited to prosecuting for third-degree rape. We felt that a 25-year sentencing ceiling for a child victim of rape was too low. As such, this act makes any rape committed against a victim younger than 17 but at least 13 by an offender at least 3 years older than the victim second-degree rape, unless, of course, other facts of the crime elevate the crime to first-degree rape. This act also makes other technical but important changes to sex offense law to ensure that justice is done for victims and that the people of our great state are protected from these predators. We would like to thank all of the hardworking men and women in our legislature. Special thanks go out to Representative Dodie Horton for putting forth this bill for us, and to Senator Pat Connick for his assistance when this bill reached the Senate. Thank you for watching, and we are all honored to serve you.